Now what to do?
Yes. The clarification in regards to the dues, I have got it. If you just want that, I can give it to your lordship. That was in terms of an order that was passed on 14th of February 2023. So that reflects in that order of 14 February 2023, my lord. In 2023, yes, my lord. That's the order that was passed, in terms of which
Yes.
yes, my lord. At page 3, the last paragraph
Yes.
of the order, IA is hereby allowed. Management so-and-so is directed to release the back wages of the applicant as per the last drawn salary calculated on so-and-so till the date of disbursement of the same. The amount can be disputed into so-and-so installment. Thereafter, the workman shall be paid his current dues until the disposal of the connected petitions. So, my lord, the first check of 12 lakhs, 11,000 was already paid on 14/8/2023. The calculation after that, my lord, I'm submitting in terms of so the first one is already paid, my lord. It's written for 1 on the top. That payment is already done. That starts from 2017 to 2022. The next chart, my lord, which is marked as 2, is the current dues that has to be paid. That's at the second page.
That is from September 22.
Yes, my lord. So that's 22, 23 to 25, 26. And the last date is, we have calculated is 30th of June 2025, and the amount is 6,22,156. This is due in terms of this order's calculation. So this is the amount which is due.
To 30 June.
Yes, ma'am. That's the calculation we've done up till 30th June, because the order says till the pendency of the
Please,
petition. July. Yes, we'll do that calculation. 22nd July. Because they do it for a year. So the period is till August, till March.
This is correct? Correct, Lord. So now I've got to take a decision on this. Decision. Correct?
Yes, ma'am. There's only one judgment that I wanted to show you last on handing over, my lord. I'm just handing over it. This is a judgment of 2024 of Madhya Pradesh High Court, my lord. In the point of whether a notice that needs to be the report to be submitted to the delinquent or not. I have already submitted one judgment, my lord. This is a later judgment where a lot of the Supreme Court judgments have already been referred. And at page 6, my lord.
Para
6. Yes, my lord. That's the contention.
Yeah.
And our contentions are at paragraph 7, the last 5 lines, 4 lines, my lord. It is also valiantly argued that even if the inquiry report has not been supplied, then nothing has been pleaded in the memo of the petition that how the appellant or writ petitioner was prejudiced by non-supply of the inquiry report. The learned counsel realized
that is ECIL Kamak.
Correct. That's the Constitution Bench judgment, my lord. In where they have repeatedly said that if it is not served, he has to at least prove.
No,
in my case, my lord, they have never come up with any kind of a plea anywhere.
But that is with but this is with regard to inquiry report.
Yes, my lord.
But that ECI case was not with regard to notice.
No, that was in regards to also an inquiry report served in one part. There's a dissenting judgment also, but they said even if it is served and it's not served, we have to only see to the extent in which he has been prejudiced. In this matter also, they have also agreed to the same principle. Only difference is in this case is that if it is not supplied, he has to plea at some point that yes, there was a prejudice that has been served because I was not served on. So that is held at page para 23, my lord. In the same judgment, they have come to the conclusion, 23, my lord. Yeah, all the Supreme Court judgments have been referred at page para 23, my lord. Thus, from the so-and-so the aforesaid decisions and different provisions of law noticed, we hold that the provisions in Rule of 55A of the rules for furnishing a copy of the inquiry report is a procedural one and of a mandatory character. But even then, a delinquent has to show that he has been prejudiced by its non-observance and consequently the law laid down by the Constitution bench to effect that an order passed in the disciplinary proceedings cannot ipso facto be quashed merely because a copy of the inquiry report has not been furnished to the delinquent officer, but he is obliged to show that the non-furnishing of such a report he has been prejudiced would apply even to cases where there is a requirement of furnishing a copy under any statutory provisions or service rules. In this case, my lord, he has not taken that plea anywhere. It is only in the cross-examination for the first time. They asked this question. We have issued a letter. The only question was whether it was served to me or not. That obviously I had no opportunity to explain it because it was put to me at the time of the cross-examination. Never that question was ever raised. Neither in the written statement before the tribunal also.
So according to you, you have served it.
Yes,
But according to him, he has not.
he's not received nothing. The copy is on record. That letter that was issued.
There is no record.
On record, yes, madam. But the dispute is whether he has received it or not. I obviously could not prove my case at that point of time because that was never an objection raised anywhere
And that issue came out when,
at the cross-examination time.
and that was the issue before the tribunal.
Yes. And not even in the dialogue. They have not raised it. His only objection was that he's a lawyer who's conducting this. Therefore, he will not be fair. That was the only ground, along with one of the other grounds is the fact that the behavior was not explained. Apart from that,
You are not clear.
because he went and shouted and it was contradicted by saying that no, that he didn't shout. It was only when he asked for his dues. That was the only difference. But in the order is very clear that he has not raised that objection ever, that I have not received that. Yes, ma'am.
So what about that portion where he said that he was not given the opportunity to cross-examine the management witness?
Yes, ma'am. That is.
Or he says that the management witnesses were not properly examined?
Yes, ma'am. Just.
That is the
Management witnesses were not examined before the domestic inquiry. Doctor.
Huh?
We did not given any opportunity to cross-examine the witnesses before the domestic inquiry.
Yes. What about that?
And all the witnesses were cross-examined before the the tribunal. And they failed to prove their case before the tribunal. All the witnesses were again produced before the tribunal. Okay. And they will duly cross-examined. After cross-examination, they failed to prove their case. And the tribunal passed the order.
So the tribunal held that the description of the respondent not proper, as much as the management witnesses were not properly examined.
Okay.
That's
Well,
the-
Well, the tribunal says that from the scrutiny of the evidence and record, it appears that the domestic inquiry not in accordance with the principles of natural justice. It is also apparent from the evidence on record that the charges of misbehavior to the manager, theft and plumbering bearing an alleged demand of money were not proved. And as such, determination of the workmen on the ground of the above charges of misconduct are not justified. And I hold the termination of workmen is not justified. So the three charges that were actually leveled against him, which one was found in his favor, 2 against him, were all reversed and said, no, none of the findings were correct. And that is how they were asked for a reinstatement of with all the back witnesses.
Let me see that.
Page 122.
Yes, my lord.
In fact, I forgot it.
Yes, my lord has in fact passed an order on
122.
no, on 5th of June, where your lordship have already dictated the,
No,
Yes.
where is the tribunal order?
yes, my lord, it starts
Page
at,
22.
Page 22.
Operating part, 122. Operating.
Huh?
my lord, it starts at page 89.
15.
Yes. The relevant portion.
Yes, my lord. The first the lordships were asking about his grievance is at page 90, my lord.
Right.
Yes,
Yes.
my lord. Yes, that's paragraph number 2, around 6 lines from the bottom.
Ah.
The workman was not given any reasonable opportunity to show cause. Formal framing of charges before taking a drastic action against a workman. So the management victimized a workman by way of a termination of service. The domestic inquiry was held by an advocate was not proper and lawful. In fact, it has not been conducted by an independent counsel inquiry officer, and the said inquiry officer is gainfully engaged by the management in other proceedings, litigation, and as such, the said inquiry officer cannot be impartial. Moreover, the management witnesses were not properly examined, which is quite unjustified and against the principle of law. There was no blemish in his service career before the aforesaid alleged incident. That is their argument, my lord.
Yes, who's argument?
This is their argument, my lord, the workman.
So what is the finding?
Yes, my lord. Now the finding is here, my lord. Minor page 104. Internal page 16.
Yes.
It's the second paragraph, minor. From the cross-examination of the management witnesses, it appears that the inquiry officer, so-and-so, was an advocate of the management of different legal matters of the management, and as such, he cannot be an independent inquiry officer as regards to the inquiry of the employee under the management. MW1 in his cross-examination admitted that the fact that there is no document to show that the notice dated so-and-so was sent to the workman. He also admitted there is no endorsement of such that the workman has received the notice. Next paragraph, my lord. From the scrutiny of the evidence on record, it appears that there is no document to come to the conclusion that the workman received the inquiry report. The requirement of law is that after conclusion of a domestic inquiry, notice along with the copy of the inquiry shall be sent to the delinquent. However, in the present case, the management has failed to do so. Apart from the inquiry officer was not an unbiased person. In these circumstances, the inquiry conducted by the officer was not proper. As regards to the charges of demand and bribery of repairing machinery of so-and-so, as well as supply of management, has not been examined the person from whom the bribe was demanded. MW2, in his cross-examination, has admitted the fact that he has not seen the incident personally and has alleged that the fact that Kuldeep Singh, MW5, in his cross-examination stated that he cannot say what was written in the evidence on the affidavit. Subsequently, he comes to the conclusion based on this.
What do you want, right? That it should be set back.
Yes, my lord. That's my prayer in the.
That it should be set back. For what?
No, my lord. Now there is no requirement, my lord.
It was that.
He was terminated way back. No.
Terminated when?
Yes, my lord. Just
11.
my lord, 12/11/2011, my lord.
12.
The entire proceedings only started after that. So, in fact, it's of 2013 reference case.
What was the fact of the case?
Yes, my
Why
lord.
was he
He,
terminated?
He was working for a garden called Kellydon Tea Estate as a fitter. Now, he is somebody who repairs machine and does small works, my lord. And in his conduct, there were a lot of allegations against his conduct. First, there were initially the management did not take any action against him. Subsequently, the allegations were converted into a show cause. He did not appear initially and did not file anything. Subsequently, after the show cause, when the second incident happened, there was another incident recorded just after the first show cause, where the management was compelled to call him. Again, he didn't turn up. And then there was an inquiry happened, charge sheet was framed, and then he was found guilty and then terminated in 2011. Yes, and the three allegations in the charge sheet, my lord, are at page 44. This is 5/9/2011, my lord. The first charge is absence of duty. 5/9/2011, page 44, my lord. The first charge number 1 is absence of duty, my lord, which was found in his favor subsequently. Number 2 charge is bribery and soliciting, my lord. The 3 firms are these from where he has asked for money after work to be done. And the third is the misbehavior where he walks into the senior manager's office and shouts at him, claiming some money which was due to him for work done. So these are the 3. And in the domestic inquiry, my lord, which starts at page 45, the issue number 1 is discussion is at page 50, my lord. Yes, my lord, that's the discussion and the decision. So charge number 1, my lord, was answered in his favor. That's at the bottom, my lord. And it went against the management. At the last line, my lord, as such, the issue is answered in favor of the delinquent employee and against the management. That's number 1. Over the page 51 is charge 2, my lord. This is in regards to the bribery and soliciting. This was in favor of the management. By perusing the evidence of the 2 witnesses, it has been proved beyond doubt that the delinquent employee had taken or soliciting bribe and illegal gratification. Therefore, I answer this issue in favor of the management and against the delinquent employee. That's at page 51, minor. And issue number 3, which is misbehavior, was also found in favor. It was inclined to hold the charge number 3 is proved in favor of the management. And against.
What's wrong with the tribunal order award?
Well, there were 2 grounds, minor. One is that the notice, and second, they said that the inquiry was conducted by a lawyer. Therefore, this is not a fair inquiry. Yes, these are the 2 grounds, major grounds in which it has been reversed. And also in regards to the allegation of misbehavior, my lord, they have said that the 2 witnesses have not come up and given a different story. But in terms of the management order, they say no, they have been examined. That is at page 44 in terms of the charge. The 3 companies. There were local companies near and around the tea garden who have called to give evidence. In fact, he asked money from them after doing the work. And this is ultimately illegal gratification, which has been proved in the inquiry. He's on 54 years.
But in the tribunal, they could not fail to prove the charges. All the 3 charges goes against the management. All the witnesses are duly cross-examined before the tribunal, and they failed to prove their case. We did not give the opportunity before the domestic inquiry. That's why they goes against us. But in the tribunal, the opportunity given to us, and they were all cross-examined.
So the tribunal did not go into the merit.
The tribunal went to the merit. Tribunal decided the case in the merit also.
Merits also.
All the
But the 2 major grounds were these 2 grounds in which it has come to a conclusion.
That technical aspect was not taken care.
These 2. Main thing was these 2. One,
No,
notice was never served. Number 2, the inquiry were the 2 main grounds. The inquiry was by a lawyer who was initially engaged, and there was some money that has been served, and he was doing the matters. Therefore, it is not fair trial, and therefore needs to be set aside. The 2 main grounds in which they have reversed it.
Lordship, besides that, my case was decided in the merit also.
It is.
Lordship,
To be that part.
that all the witnesses did cross-examination before Lordship, and they failed to prove the charges.
They failed to Prove the charges.
Failed to prove the charges, Lordship.
Basically, it's violation of natural justice. And now I think
No,
he's
Lordship,
54 years, 52 is the retirement age. So he must have, he's retired already. Technically.
What is the
No,
retirement date?
This is 58, Lordship.
Date.
I think it's 50, guardian is 58.
In some,
What is the retirement date?
50. My size is
I
58.
think it's-
That cannot be 50.
You're 50, what is the age?
54, Lord. Already I'm suffering from the. Central minus 58.
50.
58, Lord.
58, I'm sorry, 50, I'm sorry. He's 54 now,
54.
54, 55.
So on merit, besides that, the
Please.
inquiry report,
Page 93, Lord.
then
93. Paragraph the internal page 5. I'm reading the judgment.
Yeah.
About Learned Council, paragraph 6, Lord. The Learned Council for the Management has argued that there were numerous allegations against the workmen, like demanding commission for repairing the garden machine installing, plumber block bearing sorting at the office engineer manager, and those allegations made to amount to misconduct and same way
This is what
proved
they-
after domestic inquiry.
So can we move, have got another meeting? The next things that are coming up, all of things that are.
Next, week,
I'll be sitting, I think, separately. Okay. Then maybe I could. Right now we are slightly tied up. I think I've heard everything, just clarification and just finishing up the. But some thinking has to be done. I'll just fix it for next week.
Lord, sir.
Hopefully we'll finish it up. Yes, anything?
No,
Right. Right, Mr. R.P. Phogat, and passport, Mr. K.L. Gupta, and passport. Mr. R.P. Phogat, survey. That the wages of the point number 1 has been paid till June 2025.
23 has been paid, Lord. Sir.
No,
Till 23, August has been paid.
yes, ma'am.
Till June,
Just one.
till June 25.
Ma'am,
We have
you
paid till
calculated, Lord.
31st
You
of
have
August,
calculated.
31st of August 2022 is already paid.
Till
31st of August 2022 paid.
Okay.
Subsequently, my lord,
3 years,
what
yes.
remains to be paid is,
I thought this 2 has not been paid.
no,
Lord, sir.
2 has,
2 is the calculation, yes.
when are you going to give them this? Yes.
6 lakhs something has to be paid, Lord, sir, till 30th June. That time
Just give me a direction, I'll comply, I'll tell the management.
within 1 month, Lord, sir.
Yeah, but I will put-
Yes,
I will
1
put
month, 1.5 months.
particular payment, the wages have been paid till
August 2022.
August 2020. So however, so the wages payable to the petitioner till 30 June 2020,
An amount of 6 lakhs 22,000.
amounting to 6,22,154. That is calculate, the same as not been paid. This the matter. the next week.
Some time may be, direction may be given for payment also. One.
Huh?
Person.
Right?
5.
Oh, no, this is the matter next. This is the matter now. 31st, huh? 31st of
31st, I will not be. not- not
31st
be available, sir.
August, July.
31st, I will not be
July.
available. sir.
Oh.
Next, any next date, not.
Why?
I have to go outside. 31st. 31st July, sir.
Give the date.
And any date.
In the meantime, the payment to the medication.
Minor payment by 31st of it rupees typing difficult, which is a management payment. That will take
Okay,
little bit of time, my lord.
Then,
I need at least some time for at least a month, month and a half.
Fifth
months.
August.
okay,
That will be
the
fixed
main-
on 5th, my lord, and then the payment will make it accordingly.
payment paid by?
The management will have to make the payment. I'll need 1.5, 2 months, my lord, because this is, has to come, has to have a clearance from
They will
Calcutta.
fix it in August 10th.
August.
This is the matter on 21st. 21st? ठीक है?
In the meantime, they will.
I'll get
They
the
will make
instructions
the-
also, I will, whatever.
Payment will be made.
All I'm requesting is, since the payment has to come from head office and all, it takes slightly some amount of time. Worships, and keep it for instructions on 21st. I will try to make
Okay,
an effort to
okay,
complete
this
the
is a
payment.
matter on which date instructions can be.
Yes, that's all I'm.
And another date submission can be made with regard to
saying.
payment of the due amount to the.
Yes, yes, madam, that will be good. It's partnered, my lord. Will be kept partnered.
Keep